So I have the honor to introduce the lecturer of our first session today. And today's lecture is with Ms. Viren Mascarenhas. Mr. Mascarenhas is a U.S. litigator over 2 decades of experience in arbitration and litigation. He advises and represents investors and governments in arbitration, as well as defense, energy, and mining companies on a range of human rights issues. He's also an adjunct professor with Columbia University Law School. The title of his lecture today is Business and Human Rights. Thank you.
Thank you very much. Can you all hear me? Well, today is day 5, Friday morning. It's a pleasure to be here with all of you. And I want to thank the Ministry of Foreign Affairs for having me here. I've been able to attend some of the lectures sitting over here in the room, and it has been so much fun to be a student and listen to the lectures that have happened already this week, as well as to enjoy the various interventions and comments that you all have been making. So my strong and fervent hope is that you will participate in this seminar, that I'll be asking a lot of questions. As just mentioned, I teach at Columbia Law School. We have the U.S. Socratic method of teaching, so I really hope to have good participation from you all, and feel free to ask questions or make comments as we go along. Also, I understand that there are those joining virtually, so if you have any questions you'd like to send to the moderator, please do so, and we'll get through that. All right, just to give you a little bit of background of me to how I came into doing business and human rights. As was just mentioned, I do a lot of work in investor-state arbitration and commercial arbitration and U.S. litigation. When I started 20 years ago practicing as a U.S. litigator, in addition to general commercial and civil litigation, I was looking at human rights litigation options in U.S. courts. If you were interested in corporate accountability, generally in the United States in the turn of the century, you were looking at U.S. domestic law primarily, right? You were looking at civil law, you were looking at business torts, you were looking at duties that were incumbent on public companies, for example, their duties, their directors, their officers, what that they were required to do. There wasn't so much thinking about corporate accountability under international law. And one of the biggest issues that came up in the US, but I think is across the board for all jurisdictions, is how do you get corporate accountability under domestic law in domestic courts for transnational or extraterritorial harms that are committed overseas, right? And so you had to think through a legal framework of corporate formality and structure, parent companies, subsidiary companies, where they incorporated, and what are the bases for jurisdiction that we would have over a defendant. That really was the framework of human rights litigation in most jurisdictions if you were thinking about of business and human rights. So let me take a step back and ask a question. How many of you have formally studied business and human rights in international law? Let's see a show of hands. Has anyone taken that coursework, attended those lectures? All right, so we have a handful of folks in the room. Okay. I'm not surprised to hear that in a way, because this is a pretty young field. It's a field that formalized really with the Ruggie principles, which we'll go into detail in a moment, on the UN guiding principles on business and human rights that were promulgated in 2011 and that were unanimously accepted and endorsed by the Human Rights Council. And so if we take that as a starting point, although it's a good starting point, we're talking about 15 years or so, right, of this field in which we've had this soft law instrument endorsed by the Human Rights Council, and then we have seen implementation efforts at it both at the regional level, at national level, and also at the international level. And that's what we're going to cover. But it's an evolving field, right? It's a pretty young field, and therefore there's a lot to be done. And so, the way that I've structured this discussion is to go into what is business and human rights and an understanding the relatively nascent legal framework. And then I thought it would be really interesting to build on some of what we've been listening to in the previous days during this International Law Seminar Week. For example, we've heard a lot about climate change, right? And that's come up in the advisory opinion context. Professor Aurel presented a few days ago on the law of the sea and the International Court of Justice's advisory opinion. So we'll parse through and look at what are the implications for businesses under those recent judicial developments. Equally, what are the role of states regulating businesses as a result of these pronouncements that are coming out? We'll also take a look at deep seabed mining. I'll be curious to know how many of you are following what's going on. It's a pretty galvanizing moment in time right now because we are looking at what the International Seabed Authority might be doing in terms of regulations to mine the deep seabed, which is 200 meters and deeper in the oceans. We will also look at artificial intelligence and business and human rights. I know you have a seminar coming up right after this on that subject, so I'll keep my remarks brief, as I'm sure a lot more will be covered in that panel. And then we're going to do a case study. We're going to try to put you in the minds of what you are, which is government officials who are figuring out how do we as governments set up laws, regulations, and policies under international law and national law to regulate businesses in the human rights field. All right, so lots of questions for you now. I really want you to put your hands up and intervene, and I'd like to figure out, first of all, when we talk about business and human rights, what are we actually talking about? So we're not going to go into human rights law here, but if you were to raise your hands up and sort of shout out, what are the core human rights laws that form the backbone or the foundation of international human rights law? What would you identify as international human rights legal instruments? Yes?
Good morning.
Good morning.
From the pictures you're showing, I think it's the essential needs of humans and the complementary needs. So the essentials fall under the human right category.
Okay, so human rights agreements. Or treaties? What are some of those treaties?
What are some of the what?
What are some of the human rights treaties that the international community has promulgated and enacted in the last 50, 60 years? Yes? Sorry, there's going to be a lot of movement, but I know these are short questions too, so if you want to just speak up, feel free, but I know we also have to get the mics for those who are listening online.
Good morning.
Good morning.
My name is Sione from the Kingdom of Tonga. One of the conventions is the Convention on the Elimination of Discrimination Against Women.
Yes?
Yes. Thank you.
Any more?
The Convention on the Rights of the Child.
Sure.
Yes. The rights for persons with disabilities.
Very good, yes. Anyone who wants to help out our colleague, let's just get these instruments all out on the floor. Yes, please go ahead.
Good morning, Mr. Mascarenhas. The United Nations has a system of human rights. First, they have the Office of the High Commissioner for Human Rights, and there are 9 core international conventions on human rights. My colleague here has mentioned already 2 of them. In general, the international legal framework for human rights is those 9 core conventions plus other conventions and the other international organizations that protect various human rights in the various fields. Thank you.
That's right. So there's the sort of accepted 9. We've heard 3 of them, I believe. There's also the ICCPR, the Covenant on Social and Economic Rights, the Convention Against Torture, and protection of migrant workers and members of their families, and then the Convention for Protection of Persons from Enforced Disappearances. So there are those core conventions. There are also the International Labour Organization and the ILO treaties, and there are a number of those treaties as well under the ILO that are considered to be sort of core human rights treaties dealing with forced labor, for example, prohibition on child labor and trafficking, and then also collective bargaining and the right to association and trade unions. So when we think about international human rights, and I know this is a very simplified version of things because we're really exploring here the connection of regulating businesses in the field of human rights and really international human rights law. But I wanted to make sure that we have in mind those sort of core human rights instruments that we are trying to then see what accountability there is. All right, so now let's figure out what are high-risk industries that are at risk for human rights violations. You see 2 of them on the screen. I put luxury goods. You could also expand that to being the garment or apparel industry, right? So clothing, jewelry, that's one category. There's also the food and beverage industry. I put these 2 together because they have a bunch of at-risk concerns that are common to both of them. There are also some elements that are separate. So why don't we do another sort of round of questions, right? What are the kinds of risks you think, human rights risks, that you think would apply to a company that's operating in the food and beverage industry? So let's imagine that you are a chocolate company, you produce delicious chocolate, you source the ingredients for your chocolate from different parts of the world, and then you manufacture this and you put it out into the world in the form of candy bars that people are enjoying and consuming. And if a board of director came to you and said, you know, I've just been appointed as a director of this international food company, and I understand there's this thing on human rights regulation laws. I'm really a corporate lawyer. I understand corporate structure. I understand things like duty of care, duty of loyalty. I've never really thought about this from a human rights lens. You know, there are all these treaties you've just identified. You've talked about migrant workers. You've talked about enforced disappearances. You've talked about discrimination on the basis of race or, discrimination against women. This stuff is sort of alien to me in my corporate boardroom setting. What would you say? Well, let me think about your business and let me try to identify what are human rights concerns that might apply to you. So let's go with your hands. What do you think are human rights risks for an international company in the food and beverage industry?
Thank you, Professor. This is Masaret from the African Union. I would say the right to a healthy environment where plastics and that pollute the environment are involved in the production of those chocolates.
Okay. So we have plastics concern. Go ahead. Yes?
Thank you. Look, the entire supply chain from the cacao farm where the beans are grown, the conditions of the workers and their political and organisational rights to have a say in their pay and conditions, all the way through to the very store at the end of the chain in the other country where the food is sold, and the labour conditions of the hospitality workers who sell that product, to the shipping and transportation and those workers' rights, there's international labour law rights. And then beyond to the corporation who might be trying to minimise their environmental impact by offsetting emissions, but doing so in an unenvironmentally sound way without much thought as to the impact they're having through that process. So the entire supply chain from before the corporation ever sees the chocolate to well and truly after they tell their shareholders about their profit.
Right, that's a great answer. So you're sitting in Tokyo, you're at the headquarters of this multinational company, and you're saying we have to look at concerns at all elements of the supply chain. So think about the product that we as a company are putting out, and now let's go back in time to where does it all come from? Where are we sourcing it from? Maybe it's outside of Japan. Maybe it's from cocoa farms that are in West Africa, for example. And then we have concerns. Who are those folks who are farming those leaves and plants to get the core ingredient that makes chocolate? And what are their conditions there? Are they under forced labor circumstances? Are they being paid a livable minimum wage? Is there concerns about child labor that's being used there? Is there discrimination amongst laborers? Who are they choosing to agree to work with, and who are they choosing not to agree to work with? Do we have migrant worker concerns about folks who are coming into the jurisdiction to do this work seasonally and then leave? How are they treated? What are their rights? So you're right. You're looking at those things that are happening. Then there may be transportation and other things that relate to climate change and emissions, or even the conditions of the transport of these products into your jurisdiction. You yourself have to think about your own employees and workers. How are you treating them? Are you observing non-discrimination, fair treatment, and all of those principles? Now, a lot of that stuff, by the way, is accepted and understood, right? If you're a company operating here, you know that Japanese law, for example, is going to regulate how you treat workers, and that there are going to be rights of workers under Japanese law or under any body of law, depending on where you operate. So that part may be more familiar to you. but then you're also going to be looking at the product you put out into the world. So in this case, candy. And maybe there is a backlash against, using certain ingredients, high fructose corn syrup, for example. Is that good for populations to be consuming? Are you targeting certain populations to be able for them to purchase your products, even though it may not be good for them in the grand scheme? Good being, of course, a little bit of an ambiguous word. But is this a product that should be put out into the world for consumption? So those are the sort of things that you'd be thinking through. What about for luxury goods? A lot of what we've just said applies also to luxury goods. Are there other things that you think about for clothing and luxury products? Any other human rights concerns? Yes?
Good morning, Professor. My name is Hakimov. I'm from Uzbekistan. I think one of the aspects also connects to the supply chain, but in terms of how this production process affects indigenous people's rights. If, for example, the cocoa is producing in the West Africa, how this production and farming affects the habitual rights of the indigenous people. Is it affecting is it taking their lands? Is it taking their, is it impacting the cultural way of producing the cocoa in that specific area, so etc.?
I'm glad you brought up indigenous people's rights, land rights. Where are these farms, as you say? Has anyone been displaced by virtue of the company coming in to do its farming in that jurisdiction? That's a good point. In the luxury goods, think about what are these jewels made of? They're precious stones, right? So we're talking about gold, we're talking about silver, we're talking about diamonds. Who is extracting those minerals from the ground in this mining industry, and what are the conditions under which they're doing that mining activity? You may have the same concerns about indigenous groups and local communities that are being impacted by virtue of this, but you also have concerns about those who used to do this mining, artisanal mining, for example, in the DRC. What happens to those workers and the rights that they had to their livelihood, which now may be displaced because we have concessions being granted to multinational companies to mine for diamonds or to mine for gold, and those are sort of absolute rights that they have over land that previously others had access to. So a lot of what's a big concern in luxury goods right now is where are these minerals being sourced from, right? Conflict minerals, are they coming out of a conflict site? There was lots of documentaries and focus paid on Sierra Leone and West Africa in terms of blood diamonds, right? And so in the context of armed conflict, in the context of child labor, those are the issues that we have to think through. All right, so we've started going through, what are these human rights concerns? To do that, we first focused on what is international human rights law. So we have a framework for what are the human rights of individuals that cannot be violated, that cannot be abrogated. And I mentioned at the very beginning, a lot of this was being done at the domestic level, right, under sort of regular commercial or civil law on the treatment of workers and these sort of consumer concerns, the products that are being put out into the world, and so forth. But there was this issue of multinational enterprises that began to raise the question of how do we hold a company accountable for acts that are taking place in different jurisdictions, and recognizing national limits of jurisdiction in terms of how you could hold that defendant, that corporate defendant, accountable. And so in around 2005, John Ruggie was asked by the Secretary General of the UN at the time to develop principles to regulate businesses in terms of a human rights lens. And this was a project that took place for about 6 years, from 2005 to 2011. It was a very open, consultative process in which John Ruggie and his team went out and interviewed a number of stakeholders, so governments, international organizations, big multinational corporations, civil society, to come up with a set of guiding principles on business and human rights. And that is the core of where sort of we look at the soft law instrument. It's been endorsed unanimously by the Human Rights Council, but it does not have the status of a treaty. It's not a treaty. There is a draft treaty that's underway that we're going to come to, but it's a soft law instrument. Now, it is a soft law instrument that has been accepted with a lot of, with a high degree of acceptance. When you look now at multinational companies, very often in their statements, they will refer to the UN Guiding Principles on Business and Human Rights as the basis for how they are approaching the prevention of human rights abuses, to mitigate human rights abuses that may occur in the course of their business operations, and to remedy scenarios of human rights abuses that have occurred. And so you see this in the UN Guiding Principles, the sort of three pillars, of protection, to protect human rights, of respect for human rights, and then access to remedy in case human rights of individuals and communities have been violated. Now, much of this is in the context of the state's obligation. Pillar one is that states must protect against human rights abuses within their jurisdiction. They must prevent them. They must investigate potential or actual occurrences of them. They must punish when that has happened, and they must redress such abuse when it has happened. And that's, relatively unsurprising, right? The states, especially under a lot of these instruments that we were talking about, the CERD Convention, the CEDAW Convention, the ICCPR, states have obligations towards individuals who have those human rights that are recognized under those treaties. And now what was being spelled out in Pillar 1 is, states, you must not only think about what you are doing as a state actor, or what state-owned companies are doing, but also what corporations that are incorporated in your jurisdiction or whose products are being imported into your jurisdiction, you have to think about how to regulate them as well to ensure that the human rights risks and abuses that are occurring on the part of corporations are also being prevented and remedied. Pillar 2 then goes towards corporate responsibility to protect and to respect human rights. So this is a recognition that, there's a lot of corporate philanthropy, corporate social responsibility, a bunch of voluntary things that companies could do to let their shareholders know that, we're doing a good job, but we're also part of this community, right? A lot of this was community relations and outreach, but it's primarily informal, right? It's CSR programs. It's things that companies do, and oftentimes it was looked at, well, that's just because you want to be cast in a good light, but there's no legally binding obligation requiring you to do the kinds of things that fall under philanthropy or community outreach. And so the question was then, could we develop a framework for crystallizing what you should be doing, not must be doing because it's not yet the force of law, but should be doing, the guidelines on what you should be doing. And so one of the big innovations was that there should be an explicit human rights policy, that company, you should sit down together, kind of what we're doing right now here, and identify with your stakeholders, so with your supply chain contractors and subcontractors, with the employees and directors and officers who are working at your company, all of these stakeholders, with the local communities, with communities at large, and figure out what are our human rights concerns. Kind of the exercise that we just did a few minutes ago, and identify those concerns. And then we have to figure out, we're going to put out a statement that says, in accordance with the UN Guiding Principles and our sort of obligation, although it's a soft obligation, to respect human rights, we are promulgating a policy regarding our commitment to respecting human rights. And that's broken down into a couple of things. One is a policy or a human rights statement that outlines what the company is doing. Then there's actually has to be compliance with that statement. So you've got to investigate. Are you actually just putting this in words on paper and publishing it on your website? And the chairman of the board has signed off saying we have a strong commitment to human rights, or actually are you then on a continuous basis investigating your human rights risk in your operations? So you're conducting human rights due diligence. Then are you tracking the findings of your human rights due diligence, right? So it's one thing to investigate and say, well, we have a problem in West Africa with palm oil, the conditions of workers there, or we have a concern about, that we're targeting low-income families and making sure that their food stamps are being used on a particular product when it should go towards other products given their limited income. So are you then actually, what are you doing with that data, right? You have to then integrate it into your company's business and operations, track the effectiveness of your implementation, and then when you've identified problems, actually, we screwed up in these ways. These are the things that we did wrong. Remedy that, right? Make sure that those aggrieved individuals, that they have a right to be able to communicate to you that harm has been incurred, abuse has been suffered, and then what are we doing to remediate that? Some of the early work that I did, when I started getting contacted by companies asking me to help them draft these human rights policy statements, and then to also set in place these audits or set in place these processes for investigating human rights abuses occurring and then how to fix them was to say, well, what happens when the individuals who are affected are so far removed? They're not sitting at this UN university in Tokyo, but they're out in a jurisdiction far from here in another part of the world, and they're mining for diamonds in wherever it may be. How do we directly get in touch with them? So we had to think about ways in which there are whistleblower complaints, right? And actually, whistleblower laws exist in most jurisdictions, but usually it's about the complaint is where you are, right? It's about I'm operating here in this subsidiary of this big company, and they're doing something that's wrong, and I'm going to report it to the local authority. But that may not be the authority who is the parent company, right? That's operating in the United States or operating in Western Europe. How do we get it to them? And so we would have to fashion, right, a whistleblower system to allow those seemingly far-flung individuals who are impacted to be able to communicate and make sure that their grievances were heard. And that's really what access to remedy is. It's on two levels. One, states must provide remedies. That can be judicial, it can be non-judicial, it can be administrative, but also business enterprises should, or I say must here on the slide, must provide remedies. That's what the guidelines recommend that they do. So that was the UN guiding principles. I think there are 31 principles broken down into these three pillars of protect, respect, and remediate. And it got widespread acceptance, right? It was endorsed unanimously by the Human Rights Council. It's been in existence for 15 years. And what came out of that? This slide lists a number of laws, statutes or laws in different jurisdictions. Some of them are at a very domestic level. So the first one that I've listed is the California Transparency in Supply Chains Act. This was promulgated in 2010. And then we have a number of others that are on the slide. And I was thinking about ways of characterizing them. I spent a lot of time trying to group them together. You'll see here they're largely listed chronologically, right? They go from 2010 to 2024. I will also freely admit this isn't a comprehensive list. This is a lot of what forms, the ways in which human rights legislation in different countries has evolved. But there are other examples that are just not on this slide. And then I began to think, what do these laws require companies to do? Can I categorize them by subject matter? Is it about a human rights policy? Do you, company, have a human rights policy? That's what the requirement of the law is. Or do you, company, do human rights due diligence? And if you're doing human rights due diligence, into what concerns of human rights? So one of the things that you'll see here is references to forced labor. So a lot of concerns are about human trafficking, child labor, forced labor. So there are a number of these laws, the UK Modern Slavery Act, for example, the Modern Slavery Act of Australia. They're really focusing on those ILO treaties, forced labor, the conditions of child labor, and sort of collective bargaining and trade union. Those are a subset of laws. Some of the other laws just sort of want you to know, though, are you doing this? And you can say yes or no. This is the California example. California requires companies operating in California that are incorporated there or have a minimum number of employees and a minimum amount of revenue. That's usually how these laws are targeting. They're based on where the company is incorporated and usually its size, larger companies. But then if you're a California company, you can just say, I don't do human rights due diligence. And that's actually okay. You have complied with the California Transparency in Supply Chain Act. The thinking at the time, 15 years ago, was that admission, required under law, I do it, I don't do it, was going to then, that consumers would then vote with their wallets, right? That they would say, oh no, you company don't do human rights due diligence into forced labor conditions in your supply chain. We're not going to buy your product. So that, for example, was what was happening in the food and beverage industry. A lot of chocolate companies were being targeted because of child labor concerns of farm production that was happening outside of the United States. A lot of that litigation, though, consumer litigation, failed. It failed because of jurisdictional concerns. It wasn't the California company doing the abuse. It was a subsidiary or a supplier to that company doing that outside of the jurisdiction, a different entity altogether. So what was the jurisdictional basis for someone suing in California to be able to hold the California company accountable for that far removed in a different jurisdiction act? Some of these laws then expanded. They began to look at the connection between human rights abuses, but also environmental abuses. I think someone mentioned up front today about the right to a healthy environment. And oftentimes that's interpreted to mean good food, good water, living conditions. And so some of the more recent acts, for example, the German Supply Chain Due Diligence Act that's towards the bottom, that sort of goes towards a broader understanding of human rights, not just the core labor treaties, but also environmental abuses. And that's a connection that we're seeing in the human rights world being tied to a healthy environment, the right to a healthy environment. What is that? You also see lots of references to that now in the advisory opinion of the ICJ, where there's a question, have they fleshed out what the content of that right is? Is it recognized as an independent right, or is it correlated to basic rights like food, water, livelihood, etc.? And then some of these acts also go towards this extraterritorial jurisdiction issue, right? They're looking, for example, the Canadian Ombudsperson for Responsible Enterprise Initiative, that's actually looking at parent companies. What are you doing to regulate your subsidiaries that are operating overseas? And some of this was a response to cases that were happening in these various jurisdictions. So for example, around the time that Canada promulgated this act, there was a case, Newsom, that involved whether to hold a Canadian company responsible for mining human rights abuses that occurred in Africa. And so some of this is responding to real-time developments. For example, the connection between human rights and environment that we're seeing in the international law community. Some of it is responding to jurisdictional limits that we're seeing in statutory domestic legal frameworks, as well as case law that's coming out of it. One of the things you'll notice on this slide is we're primarily talking about North American and Western European companies, right? Now, they implicate companies that are outside of these jurisdictions. So for example, you can be an exporter, a company based in Asia, a company based in an African country who's exporting something or supplying something that goes within the European Union, for example. This is what the Corporate Sustainability Due Diligence Directive is. It applies to companies that are within the EU, but also if you cross a certain size and threshold for either workers that are in the EU or the amount of revenues you derive from sales within the EU, even if you're outside of it, you may be subject to their reporting requirements. This was actually another wave of questions that I received from companies a few years ago. Actually, in that case, with the Norwegian Transparency Act. Norway passed a law that said, we want transparency in supply chains. We want to make sure that you company, Norwegian company, are asking your suppliers who come from all over the world whether they are taking the right precautions to minimize human rights abuses in their operations as they pass their product onwards to you. And so I had a US-based energy company say to me, what is this? Why are we being asked to fulfill a requirement that our counterparty in Norway has? We have to respond, and they're asking for the basis for their request for that information is the Norwegian Transparency Act. And if we don't provide that information, their response to the Norwegian authorities will be, our supplier in the US has declined to answer or provide this information. And what does that mean then for the Norwegian company? Can they continue to do business with us? Well, perhaps. It depends on what the Norwegian law requires. Does it require you stop working with those suppliers? It doesn't go that far, but likely will you, because you're then exposing yourself to potential litigation in Norway, right? If I'm a diligent human rights lawyer and I'm going through the responses of companies in Norway to the Transparency Act, and I'm seeing you, very successful Norwegian company, are admitting that some of your major suppliers don't do human rights due diligence or have not responded to your audit, but you're continuing to do work with them, can I fashion that into some domestic litigation challenging you for failing to live up to your human rights obligations? So even though some of these instruments are national, they're promulgated at the domestic level, they have an impact that is outside of their borders. Now, I did look, for what have been efforts in Asia and Africa, and, again, I'll admit, this is me going to Google and looking at things, right? I've not systematically gone through each jurisdiction to find out whether laws on the books translate into the kinds of things we're seeing with mandatory human rights due diligence, mandatory statements on anti-slavery, anti-human trafficking concerns. There are, the Japanese Ministry of Economy, METI, promulgated guidelines on respecting human rights in responsible business supply chains in 2022. There are other initiatives that are underway in South Korea, for example. There is pending legislation. Thailand currently is drafting a legislation that connects human rights and environmental due diligence legislation. I wasn't able to find a draft text of it online. There have been some discussions, at the ASEAN level about looking at the Intergovernmental Commission on Human Rights and what should be done to regulate responsible business conduct. But those are still pretty, as far as I can tell, nascent efforts. I've also looked at some of the African Commission on Business and Human Rights in Africa. They've issued statements in 2023. There have been some soft law instruments coming out of civil society urging, intergovernmental organizations such as these human rights commissions to go ahead and promulgate national guidelines or regional guidelines, but we're still seeing that phase develop. And then we come to the draft treaty on business and human rights. So I said to you, we have the UN Guiding Principles on Business and Human Rights, soft law instrument. We have all this stuff happening at the national and regional level. Some of it is more advanced. By advanced, I mean it's been converted into hard law. It's got the force of law and is binding. One of the things I should mention, by the way, is over time, those instruments that I discussed, going from the Supply Chain Transparency Act in 2010 to whatever was the last one, the Corporate Sustainability Directive of the EU in 2024, they have been adding teeth to what it means if you don't comply. We're going to go into what that is on another slide, but it used to be the case, as I said, you could just say, we don't do anything, and that was compliance with the law because you were reporting. Then there was, okay, we're doing something, here's what it is, we're doing human rights due diligence, and that is compliance with the law. But then the question has become, if you now say we don't do anything, what are the consequences that follow? And some of the more modern legislation does have some penalties and so forth. All right, so now let's take it from the UN Guiding Principles and let's go to the Office of the Human Rights Commission, Commission for Human Rights. 11 years ago, in 2014, I believe, there was an effort to let's take these UN Guiding Principles and convert them into a treaty that's going to hold states that sign on to and ratify that treaty accountable for regulating businesses that are at risk of committing human rights abuses and for preventing when that has occurred. The treaty negotiations have been ongoing for the last 11 years, and there are a couple of issues that are stymieing why this has not yet gone to being a final draft and being ratified. One of the issues is, what are we regulating in terms of businesses? The UN Guiding Principles mention all businesses. You can be a small shop that's in one jurisdiction, that's on one location, but in theory, under the UN Guiding Principles, you are responsible for living up to whatever is in the UN Guiding Principles. On the flip side, you can be the biggest company in the world that has operations all over the world, and you are also responsible for fulfilling those obligations in the UN Guiding Principles. There's an acknowledgement in the Guiding Principles that what it means to comply, depending on are you tiny in one place with your customer base being the 50 people around you, or are you a multinational company? There's a recognition that different scale and effort has to be undertaken. The question here, though, is in the Business and Human Rights Treaty, should it be all businesses or should it just be transnational businesses, right? Because this concern really came about jurisdictional limits of countries in enforcing laws to hold companies accountable because of extraterritorial or transboundary harm that they were causing. And so there's been this question of should the treaty be really regulating multinational enterprises versus a much larger base of every single business? And what does it mean for a state that then has obligations towards every single business within its jurisdiction? So that's one issue. There's also a question of the definition of victim. The treaty says victim, the draft treaty says victim shall mean any person or group of persons who suffered a human rights abuse in the context of business activities, irrespective of nationality, irrespective of domicile. It may also include, and this comes from human rights law, immediate family members or dependents of the direct victim. Right? So there's a pretty broad definition of victim that's within this treaty, which makes sense if it's a human rights treaty or drafted within this law on the core documents that we were discussing. There's also then a list in the treaty of the statement of purpose. What are we meant to do? Most of these obligations are for states, what states are meant to do under the treaty. And this makes sense, right? We're used to treaties regulating the obligations, setting forth the obligations of states and the rights of others under those treaties, for example, individuals or victims. But really, it's up to the states to enforce. There's also a question then about direct accountability of businesses under the treaty. Could we say that businesses must fulfill the obligations under this treaty? And that's been a major sticking point, right? That can we impose obligations on companies directly that if they're not living up to, third parties, such as victims, can sue those companies directly under the treaty? Now, you had You had the lecture yesterday of Catherine Amirfar, who talked about investment treaty arbitration, right? And there was this whole discussion about counterclaims and whether states could also sue investors under those investment treaties, saying, you're not living up to whatever you're meant to do. And there was this discussion of all disputes, and does it apply only to investor-brought claims? Could it cover, in principle, or depending on the text of the treaty, state counterclaims? So here there's a question of, can we create under these treaties direct obligations of companies under these treaties that if they fail to live up to those obligations to protect, respect, remediate human rights issues, that then third parties, maybe states, maybe victims, could seek to hold them accountable, and in what forum? Would it be in national courts? Would it be in private dispute settlements such as arbitration? There's an uneasy relationship between human rights and arbitration. Many of the virtues of arbitration that we talk about in the commercial setting, such as confidentiality, that is removed from a judicial system, so you may not have potential bias of the local courts. They may not apply as much in the human rights context, where a lot of human rights litigation is conducted in national courts, but usually because it's victim versus state, right? And that's usually been the framework if it's an international human rights violation. So there's this question of direct accountability of states under the treaties that's an issue. That there's also a question on jurisdiction. How are we defining what states must do in terms of jurisdiction? This is that classic problem, right? The limits of jurisdiction that states have over third-party defendants. And so the draft treaty is pretty broad, and it covers, for example, human rights abuse took place in whole or in part within the territory or jurisdiction of that state party, so a territorial-based jurisdiction. The relevant harm was sustained in whole or in part within the territory or jurisdiction of that state party. And so this sort of covers stuff that's coming into the jurisdiction of that particular state from outside. The harm is being felt or received within the territory. And then there are other examples, that are sort of trying to expand and get towards extraterritorial jurisdictional bases to address this limitations of jurisdictional problem. And that's one of the issues that's being identified in holding up the treaty. There's a lot of hope, from international civil society that this treaty will be promulgated, because one of the concerns of that list that I presented to you of domestic legislation is that it's a patchwork, right? It's different states that are doing different sizes of companies. It's where are you incorporated? What's the size of your workers and employees? What's the size of your revenues? Who are you importing from? Are you in the EU? Are you in California? Are you in France, for example, which has its own national law? Do you have to do French law and EU law on the Corporate Sustainability Directive? Do they all ask for the same things or different things with what penalties and consequences? And if you are me advising multinational companies right now, the patchwork is a problem, right? Because it exposes you to different standards of accountability. And so what you're actually seeing now is when companies are putting out sustainability reports, or their annual reports are dealing with corporate sustainability, human rights issues, there's I won't say race to the bottom, but there's a question of not trying to tier that under this law we're required to do this, and therefore we have ratcheted it up, while under this other law we're not required to do whatever it may be, and so we are not reporting as having done that or not having done that. And the reason is because, again, careful lawyers are reviewing, or careful victims are reviewing these statements that are being put out, and you're always looking for differences in treatment, right? Because you then may be able to discern from different disclosures, different obligations, pursuant to different laws, a differing standard of treatment, which could then be the basis for a case that a company is not doing the right thing under applicable human rights laws. And so we oftentimes, when I'm advising companies, will say to them, let's look at all the laws that are applicable to you, and then what can we do to make sure that there is a common statement of conduct that goes towards the top of that, the highest obligation, so that you then cover everything that's below. But this is a very delicate dance, because you are looking at national laws and regional laws and different companies and subsidiaries and affiliates and how they're operating. So the patchwork of laws is a real challenge. Okay, so I said we would talk about consequences of non-compliance. So sometimes it compels a disclosure. Are you doing this? Yes or no? Then there may be consumer scrutiny that recognizing, oh, well, this company is sourcing from, workers in very poor conditions in Bangladesh. Are we concerned about these garment workers, and therefore are we going to buy the products from this multinational company, or are we going to say, no, we're not buying from that particular company anymore? There may be investor scrutiny. Especially if you're a publicly traded company, your investors might be looking and saying, well, actually, I'm not interested in investing anymore in this particular company because look at this practice that they're doing. And so shareholders might vote with, selling their shares, the share price being depreciated. But there are also other things, monetary penalties, for example. The EU Corporate Sustainability Due Diligence Directive provides for up to 5% of a company's net worldwide revenues or turnover for a period of non-compliance. So it's not good enough to just, do stuff on paper. It's if you're not complying with what you're required to do, then you're going to have to pay a monetary fine. We're going to define what that fine might be. It may also be, depending on the statute, that there's empowerment of the local authorities and regulators that they can seek injunctive relief, compel you to do something, right? So recently, under the French duty of vigilance that France has enacted, there was a company that faced a law, or it wasn't a lawsuit, it was a notification by a trade union that essentially said that, the subcontractors of La Poste, a French company, they are not doing diligence into their undocumented workers. And the conditions of those undocumented workers in the supply chain is abysmal and doesn't satisfy their basic human rights. And so the regulators ordered La Poste, in this case, to enhance their risk mapping and due diligence to make sure that they were investigating this issue of whether their subcontractors were, in fact, using undocumented workers and what their conditions were, with the requirement of reporting back then to the authorities on what they had done to change or improve the situation. It may also be the case, this is in the German Supply Chain Act or the Diligence Act, that you will be excluded from public procurement. So if you are not living up to these standards, you're not allowed to participate in public procurement processes. So these are different ways in which penalties are being imposed on companies for non-compliance. And there is a movement that you see towards having more teeth. Now, there may be questions from those who are human rights litigators and are in the field of human rights, is this good enough, right? Because when we talk about those core instruments, right, the core 9 treaties, the 3 or 4 core ILO treaties, is it good enough to say, well, investor scrutiny is the problem that the company will face, consumer scrutiny, they won't buy the products anymore. What about the fact that there has been a human rights abuse that probably isn't good enough under international human rights law for remediation? All right, so that is the framework of the laws that we have. Are there any questions on the status of where things stand at sort of high level? Yes.
Thank you, sir. I would like to ask the question about the length or the extent of the accountability or responsibility for businesses when it comes to their counterparts, or we're talking about the supply chain line, which might be very complex and complicated for multinational companies. They might get products from, let's say, they're based in country A, they get their product from country B, and then producers in country B are distributing or getting distributed from country C, D, and E.
Right.
To how many levels does country A, businesses in country A, have to make sure that their businesses' supply chains are in compliance with human rights standards? Does it go all the way to the farmer from the very first beginning of the products when they're produced? Or was it just like first tier, second tier, and all that?
Sure.
Thank you.
It's a great question. It's a really difficult situation, right? Because you have to also be realistic in the situation of if you are Apple and you have the weight. So let me take a step back. The answer is it's unclear, right? It depends. It depends, to give you the lawyer answer, unfortunately. A lot of this comes down to contract law, right? When you as a contractor are dealing with a counterparty, are you putting into that contractual relationship terms that say, and one of your obligations is that you in turn are looking at your suppliers and ensuring that they are living up to whatever is the content of our human rights due diligence statement that we have put out on our website. right? That's one way in which this is being addressed, that we are removed by 1, 2, 3, 4 degrees, so we can't necessarily do that job. But can you put as a representation and warranty in your contract with us that you are conducting a human rights audit, that you are doing the things that your suppliers in turn are living up to what we're expecting of you? And if the answer is no, that we find this out, either because we have independent audit rights or because it's come to light in some way, that we can then sue you under the agreement for failing to live up to your contractual obligations. Now, that might still be a little bit of an unsatisfactory solution, right? There's a way forward there. Maybe it allows for material breach of the agreement. You can terminate the relationship with that supplier. There still, of course, is the victim that's suffered this human rights abuse, and we have to figure out what their remedy is. But these are the ways that companies are dealing with it. They're taking their general standards of business and human rights conduct, their human rights due diligence statements, and in their negotiations, their commercial negotiations with their contractors, their subcontractors, their suppliers, saying, in turn, we are expecting these things of you as a representation and warranty that you are doing them. We may seek audit rights additionally, that we will be investigating whether you are in fact living up to your standards. And in the event that something untoward is found out, that we have contractual remedies to either terminate our relationship with you or hold you accountable or require you to do something. That's usually a way in which this is being addressed. It also goes towards bargaining power, though, right? If you're a small company, realistically, are you going to be able to impose these kind of obligations on your counterparties? Because contract negotiations are all about how much power do you have and what matters to you. And are human rights concerns paramount and important to you, which they should be? Or are you more focused about things like, how much of my product are you buying and at what price, right? And that being the commercial basis for our relationship, and this other stuff being additional, aspirational, so there is that question. That being said, the largest multinational companies in the world do have more of that negotiating power to sort of hold in line suppliers down the supply chain. So that's something we would expect from them. Any other questions? Yes.
Usually before the multinationals are held to account for actions that happen in their subsidiary in another country, there's an expose. Usually there's an expose. The journalists have done some investigation or something. Now, I have seen instances, I'm from Kenya, I've seen instances, for example, in the tea industry, we've had a lot of human rights abuse, where once a company is exposed, they immediately sell the company to another company. And so it becomes difficult to hold the original company into account because you do not know who you are supposed to hold into account. As a lawyer dealing with business and human rights, how do you approach such a situation? And to what extent should, say, the subsequent companies be held to account for the tortious actions of the first company?
Sure, very, very good question. So I guess the short answer to this is that in the M&A transaction, where you are either spinning off or you are selling the entity that now has the problem or getting it away from the company that did cause the problem, it probably was the case that those corporate M&A lawyers who were sitting in Tokyo and sitting in New York and sitting in London and sitting in Nairobi were not looking at these kinds of concerns about human rights abuses or environmental abuses and impacts on local communities. Rather, they were looking at other things, that when you were making a representation and warranty that your revenues were of a certain amount, that's the part that mattered because they were looking at the commercial terms of that transaction. They were not looking at some of this underlying due diligence. And if they were looking at existing litigation or the threat of litigation, that it was for the kinds of things you'd expect, such as, are there any employee lawsuits against you, pending lawsuits against you under local laws or applicable legislation. Now there is a trend towards, in these M&A transactions, in these sort of corporate transactions, a recognition of potential human rights abuses being brought in. And it will be addressed in some instances, not all. This is a new field evolving, but you're going to see provisions in those agreements that are going to be looking at, well, if there are human rights issues raised under these treaties or these kinds of instruments, who's going to be held accountable for it, the buyer or the seller? Are there temporal aspects for past work that was done, but then new work being done forward? That will try to be contracted for. And that's actually a pretty good development, right? Because it could mean then that at least between those companies, there is accountability that's being addressed. That's one of the, I think one of the most promising parts of human rights laws that are being promulgated, which is this aspect is being taken into account now in the contracts, right, with suppliers, in M&A transactions, because there's a recognition of exposure and potential liability, and that's now being contracted for. That's not always going towards necessarily helping human rights victims, but it is something that's an item that's being discussed in the boardrooms and in the meeting rooms. All right, climate change and business and human rights. So I had the honor last year, and maybe in 2023 as well, of working with some of the UN rapporteurs on human rights and the environment, human rights and climate change, the right to be free of toxics, on submissions that were being made to the International Tribunal for the Law of the Sea and the Inter-American Court of Human Rights. And a very important issue for them was the connection between climate change, which is the subject of these advisory opinions before the ICJ, before ITLOS, before the Inter-American Court, and human rights. And so I want to go into that for a little bit. All right. First, though, there has been a trend. I talked about all those trafficking and modern slavery legislations that were on that previous slide. Then I made a connection and said some of the more recent legislation is the connection between human rights and environmental law. There are also laws that are on the books that talk about climate change disclosures, that you have to address the impact of your operations on climate change, and in particular looking at Scope 1, Scope 2, and Scope 3 emissions. Scope 1 and Scope 2 are essentially emissions that the company, greenhouse gas emissions that the company puts out into the world by virtue directly of its operations. Scope 3 emissions are what others in the value chain or supply chain that are linked to that company's business and operations are putting out into the world. And so that is now, you typically see a discussion in the legislation of disclosing Scope 1, Scope 2, maybe Scope 3 emissions. There's materiality, certain thresholds that you have to show as to how this is impacting your financial standing, the work that the emissions that you're putting out. There's a reporting on whether you're offsetting using carbon credits. So there are different requirements in these local laws. There are timelines for disclosure. A lot of companies have not been tracking this stuff formally. So when does that go into effect? And so that's what we see in terms of these disclosure laws. They're kind of like, the first generation of disclosure laws on anti-trafficking. Like, tell us what you're doing, and then we'll figure out what that means. Usually the figure out what that means is in the form of shareholders being upset or consumers being upset, but we're seeing a connection now towards what that means in terms of human rights abuses. There is a lot of human rights litigation that's taking place on the connection between climate change and human rights. Some of this is taking place before European and Inter-American Court of Human Rights or regional courts. Some of it is taking place in national courts, and they're grappling with some of these issues of conduct in X-jurisdiction with impact felt in Y jurisdiction, that transboundary harm. How can we hold companies accountable? I've just put two examples on the slide here. One is significant human rights litigation against the Netherlands in Urgenda Foundation. This basically was litigation in which a not-for-profit said, you Netherlands government are not living up to your obligations under the Paris Agreement, your national contribution determinations for achieving 2 degrees or 1.5, and you have not taken sufficient steps to be able to achieve those targets based on the level of emissions that the Netherlands has a percentage or proportion of. And in that litigation, the Dutch courts agreed, and they said, actually, that's right. You government need to be taking more steps if we are to achieve what is being set out. And they actually imposed a requirement then on the government to take certain actions. So this was a bit of a controversial decision when it came out, very much celebrated by human rights activists, but a question of are courts moving into policy and regulatory space? Yes, there's a treaty that sets out what states are meant to be doing, but typically it's up to the states to figure out how to achieve that goal. And is it right for a court to say, and can a court be in a position with whatever best available evidence is to then tell the regulatory bodies, the legislative bodies, you should have actually done something else instead to achieve those goals. So there is this delicate relationship right now that we're seeing in human rights litigation, where courts are stepping in to say, yes, that's right, you've not lived up to your international or your human rights obligations under the European Convention in this case. I think it was Articles 2 and Article 8 on the right to private life. And so you must be doing something, and you're going to be held accountable, government, for that. There was also not really a parallel case, but a related case that was brought against Shell, which is a Dutch company, by sort of, again, a not-for-profit. And it was looking at whether Shell had not taken the steps that it was saying that it was taking in its public disclosures and so forth to reduce carbon emissions. And it was making the sort of an allegation that Shell was putting out that it was complying with emissions reductions targets, but that in fact it was not doing so. The litigation also looked at new investment projects in different oil and gas fields that Shell was contemplating investing in, and so the question was raised: if you're continuing to do extractives, oil and gas exploration and production, which is new projects, how can that be that as a company you overall are living up to GHG emission reduction? The first instance court, the district court, ordered Shell to reduce its CO2 emissions by 45% by 2030, right? And that came out in I think it was a few years ago, and it was compared to 2019 levels. So the Dutch court, the district court, the first instance trial court said, you, Shell, need to take certain steps to reduce your CO2 emissions by 45% by 2030 when compared to your CO2 emissions in 2019. And they sort of relied on the corporate duty of care to make this finding, but they mentioned in the decision the UN guiding principles as what Shell should be doing to fulfill those obligations under the UN guiding principles. But they also relied on business torts under Dutch law, right? So this sort of patchwork of national laws and then also soft law at the international level. They covered Scope 1 emissions and Scope 2 emissions, but they also included Scope 3 emissions in the calculation of what Shell's total emissions were. Scope 3 being, everything in the value chain, right? That's associated with products after they are sold. So that can substantially, if you're an extractives company in the energy space, increase your total emissions. On appeal, the appellate court sort of had good language supporting what the lawsuit was brought by these claimants, but they essentially said, we have insufficient knowledge and evidence to be able to tell you to reduce this by 45%. That determination by the district court went too far. And so there was a question then of, the calculations, the scientific evidence, and the role of the court in stepping in to order a Dutch company under Dutch laws, and maybe the UN guiding principles, in achieving CO2 emissions. So it's a little bit of a mixed bag for some human rights activists. It still is a pronouncement that courts have a role to regulate companies under national laws, which has always been the case. But then, a little bit of a difficulty in terms of figuring out what the remedy is there. And for those of you who've read through the ICJ advisory opinion, towards the end there's a section on loss and damage, right? And it goes into causation, it goes into attribution, and it goes into sort of remedies in terms of monetary or satisfaction or restitution. And there's been some criticism of the opinion that while it does cover those areas, and the opinion references that in the right lawsuits with the right evidence, there can be accountability. It doesn't spell out how that should be done. And that's a lot of what we're seeing in human rights litigation. In the climate change world, there's a question of attribution, there's a question of causation, and how do we calculate accountability? So that's one of the challenges that happened in this particular case. All right, so I want to go into the advisory opinion because I think it connects nicely to what was discussed yesterday on the ISDS front. It also connects to Professor Orell's presentation on Law of the Sea and then her second presentation on the ICJ advisory opinion. But I'm only looking at this from the perspective of business and human rights. And I unfortunately don't have the paragraph for the second citation on the slide, but the first paragraph comes from paragraph 282. And the question here for the court in its advisory opinion, it said, these rules and measures must regulate the conduct of public and private operators within the state's jurisdiction or control and be accompanied by effective enforcement and monitoring mechanisms to ensure their implementation. Right? And so they are referring then to what states have to do to reduce greenhouse gas emissions, and they're making an express connection to private operators within the jurisdiction or control of these states and what states must be doing to regulate that conduct. And so that's sort of a link then to say it's not just you states, but it's also what actors, corporate actors under your jurisdiction and control are doing. And then they really double down on focusing on the fossil fuel extractives industry, right? So in whatever paragraph it is later, it says, failure of a state to take appropriate action to protect the climate system from GHG emissions. And then it says, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies may be an internationally wrongful act. That sort of goes back to even the Shell case, right, where there was this sort of examination by the Dutch court on new projects that Shell was contemplating, and now you have this language that's come out, 1 or 2 years later in this advisory opinion that's suggesting that going on to have new exploration projects, new extractives, exploitation might be, may constitute under the right circumstances an internationally wrongful act. So there is a connection here on business and human rights in the climate change context, and then especially energy companies in oil and gas exploration and production. If you go through the joint declarations, you also see this connection being made. I focused here on the joint declaration of Judges Bandari and Cleveland, and here they say in paragraph 23 of their joint declaration, the obligation of states to mitigate the potential harms arising within their jurisdiction or control under climate change treaties and customary international law thus include phasing out of fossil fuel dependency, including by directly taking into account and redressing the downstream consequences of production, licensing, and subsidy activities. That language towards the end is sort of scope 3 emissions, right? It's looking not just at what you as a company are contributing to greenhouse gas emissions in your direct operations, but everything else that derives from that. And so it's also, by the way, there were questions to Ms. Amir Farr yesterday, right, about how do we regulate the energy industry under these investment treaty cases, oftentimes which turn on the granting or the termination of exploration licenses, of exploitation licenses. So you're seeing the International Court of Justice wade into that state of the law in the advisory opinion itself, but as well as the joint declaration. You see it in the declaration of Judge Cleveland. She's actually talking now here in the context of international investment agreements, right? And there was a question yesterday, how do we regulate this? Do we have exclusion clauses? Do we enumerate the rights of states to regulate includes for climate change concerns? The text of those treaties matters. So here, towards the end of paragraph 22, Judge Cleveland says, the interpretation of investment instruments must be informed by states' obligations in respect of climate change under international law, including the stringent due diligence standard to which states are bound in implementing such obligations. So there's a recognition here of investment, foreign investment laws and investment treaties, and the role that they may play in climate change. Any questions on where we are right now, climate change and human rights? If you look at the Inter-American Court of Human Rights, there's much more of a discussion on the relationship between climate change and human rights, because that body of law, the Inter-American Convention, was squarely in front of the court there, right? Here in this ICJ advisory opinion, there's a good structuring of climate change treaties and then different sources of international law that might be relevant, including a section that deals with international human rights laws, but they're looking at a sort of holistic view. The Inter-American Court was really looking at, human rights listed in the Inter-American Convention and how states have obligations to protect those rights enshrined in that convention, which may be impacted adversely by climate change. So that opinion is more, I don't want to say robust, but is more comprehensive. Let me put it that way. Okay. And I guess that's what the next slide goes on to say, that, especially in the context of the investment treaty world, in paragraph 163, the Inter-American Court says, this tension is not inherent to the investment regime, but depends on the regulatory design and use of dispute settlement mechanisms. It is therefore drawn attention to the importance of striking the right balance in investor-state dispute settlement mechanisms, which allows states to adapt and modify their legislation in the face of the climate crisis. So here there's sort of an even more express recognition of how are we meant to be interpreting these investment treaties in the context of the climate emergency. All right. Now, what was interesting about Professor Oral's presentation was she talked about the BBNJ treaty, right? And how one of the big innovations there has been really robust focus on environmental impact assessments and making sure that they include now the impact on marine pollution, which in the context of the law of the sea would include man-made causes of greenhouse gas emissions. So I've just, on this slide for you, put down various paragraphs of the ICJ advisory opinion that go towards, this stringent standard of due diligence, right? That states have a duty under customary international law to prevent significant harm to the environment. And then there's a recognition that the duty is not confined to cross-border harm, because a lot of the ICJ decisions on this issue of transboundary harm were in the context of two states, but also applies to global environmental concerns, which is climate change that impacts the globe at large, and that the duty to prevent significant harm to the environment is an obligation to act with due diligence, but then a spelling out that for significant harm to the climate system, that standard is stringent, and the higher the probability and the seriousness of possible harm, the more demanding the required standard of conduct. And this is stuff that we're seeing in the BBNJ Treaty, where there are a lot of provisions that deal with, before you are to undertake activities relating to those marine genetic resources, we have to make sure that diligence is conducted on the proposed activity, and that all stakeholders, which is more broadly defined in the BBNJ to include civil society and affected stakeholders, are consulted. And I think you're seeing sort of parallel language that's setting the foundation for that here in the advisory opinion. So I want us to go to deep seabed mining now as one of the major concerns that we're facing. And there's a reason why it's very topical at the moment. Who's familiar with what's going on at the International Seabed Authority in terms of exploitation of the deep seabed for mineral deposits? Can anyone tell me where things stand on that front? Yes. Maybe just wait a moment for the mic, if you don't mind. It's here in the middle.
Thank you. President Trump gave a concession to Canadian company for digging for minerals in the seabed.
Right. So very recently, the United States, under President Trump, there was an executive order about deep seabed mining exploitation outside of the exclusive economic zone. That's not unique to the United States. There have been other unilateral orders or steps that have been taken. Within the context of UNCLOS, remember, when we were talking with Professor Orel about the grand bargain that was struck in the 1980s, there was a concern then about the exploitation of deep seabed mining and making sure that developing countries were not being left behind, right? And there was a real focus on the common heritage of humankind that's embedded in there. Well, what's been happening in the last 20 years is that you have the International Seabed Authority, which has jurisdiction to figure out these issues relating to deep seabed mining, which is, the seabed, the ocean floor, and what's beneath it at a certain depth, which is over 200 meters. And, it used to be considered that this is, stuff of a fiction, right? That we can get down there and actually explore the seabed and then actually extract minerals from there. And what we're seeing happening now is that this is becoming possible. I have represented companies and I've represented governments in disputes over exploration concessions and exploitation concessions in shallower waters, but you have a lot of the same considerations there because, you have to make sure that you are taking the best steps to prevent environmental contamination and degradation of the ocean floor and the ocean at large, right? We think about oil spills and so forth, and how do we contain this? Think about drilling or dredging the ocean floor. How do we prevent accidents from happening? And if accidents happen, how do we contain them? So this is very topical right now because the International Seabed Authority promulgated regulations on exploration activity, right? So going to scout whether something has the possibility commercially and technically to be exploited on the seabed floor. I do a lot of work in the extractives industry. I do a lot of cases for and against energy companies and mining companies. When you're at the exploration level, right, there is minimal activity. You're not actually drilling in the sense of extractive removal of the product from whatever it may be, the oil deposit, the mining deposit. You are largely scouting using 3D seismic testing. You may also be doing some limited drilling activity, but it's to derive two basic measures of whether something can go forward or not. First, is it commercially possible to do this? And second, is it technically possible to do this? And then there's an environmental component to this. Can we make sure that in doing this, we take best practices and we mitigate and have measures in place to prevent environmental harm from happening? Usually you have that process under exploration and the environmental permit. When you satisfy all of those boxes, you may then apply for a concession to actually develop and exploit that mining deposit or that oil and gas deposit, right? So now the question, though, is we've been having exploration done. What about exploitation? Have we reached that phase? And there was within the framework of the International Seabed Authority and the related agreements, discussion about exploitation regulations had to be promulgated within a certain period of time. And unfortunately, or fortunately, those regulations have not yet been promulgated. And so a couple of years ago, Nauru said, actually, we're going to trigger what is a 2-year rule, which is if you, International Seabed Authority, do not issue these exploitation regulations to govern exploitation activity of the deep seabed, then we're going to have to, countries and contractors are able to submit applications for that exploitation activity, and your dereliction of duty, not promulgating these guidelines, cannot hold up that activity. And that's actually what's put a lot of pressure right now. That's individual countries like the United States with the executive order, but also applications to the ISA, the International Seabed Authority, to say we're ready to go. We have the technology. We think we can do this in a responsible way. You have not promulgated those regulations. There was a 2-year rule. We started it. That 2-year period has ended. This has put a lot of pressure right now on mining companies that are looking to do this extractives work in the deep sea. And in the advisory opinion from the ITLOS tribunal, they also made reference then to the standard of due diligence when you're investigating whether certain exploitation activity can take place in the high seas, or including now this sort of marine activity. And they identified in Article 194 of the UNCLOS Convention the stringent standard of due diligence. So I think that's where we are right now. We're trying to wait and see what's going to happen, but it's a very off-the-moment concern, where the ISA, many states have petitioned that they stop actually, sort of have a moratorium and say we're not ready yet because best available science doesn't show that this kind of exploitation activity can be done in a sufficiently safe manner, but it's very much topical of this time. Any questions on the deep seabed mining and the connection to mining companies and business and human rights concerns? Because this is one of the big moments, one of the big issues of the moment. Okay, let's go to the next topic, artificial intelligence and business and human rights. So at the very start of today, we talked about, all right, if you are a food and beverage company, we're all gathered in this room, we're all smart people, let's think about what are the human rights concerns that come out of being a multinational company operating in the food and beverage industry. We also looked at luxury goods. We identified, for example, minerals that may come from conflict zones, so we have some concerns about that, and we identified a list of other concerns. If you are an AI company, an artificial intelligence company, you are a tech company, and now we have the same question. I come to all of you and I say, I've just been appointed the chairman of the board of this artificial intelligence company, and I want to make sure that I'm complying with human rights obligations, whether hard law or soft law. What should I be worried about or thinking about? What would you say to me? What are the kinds of human rights concerns you have in this field? Yes.
The use of consumer data.
Human data? Okay, what does that mean?
Currently, I am passionate about the area of ICT. So for me, I look at data as currency. What's happening is that we have the big IT companies now who we assume are holding data in trust for consumers. But then how do they exploit this data?
Okay.
I think it's what shapes the industry. So do consumers have consent to how their data is used? Because now you can be talking about Adidas shoes when holding your phone, or you search Adidas shoes and then now you keep receiving advertisements on Adidas shoes, and that you have the whole day. Or once you book a flight, such things. And many other issues, because now the consumers' data is what shapes the industry. And then we also have safety,
Mm-hmm.
Now I'm looking at a more advanced issue on, say, robotics. Let me use China as an example. Say, robot is manufactured in China, and then we have it's sold, say, in Africa, in Kenya. So once it does not, what is the scope of this robot? How safe is it for humans? Because now if it harms someone in Kenya, how do you deal? It was to serve in a hospital, but then it turns and harms the patient.
Mm-hmm.
So how are you supposed to deal with such issues where international trade in such products is concerned?
Great. So that's very comprehensive. You're looking at issues of the data set, privacy concerns, but also the quality of that data set that's used in generative AI, where you put in a prompt and then based on the data, AI is giving you an answer. You also touched on agentic AI, right, where there's autonomous activity done by the robot in Kenya in the hospital and accountability for what it may be doing. There was another hand up front.
I think my colleague has pretty much covered. I was just thinking if plagiarism would also be one of the issues.
Yes.
Not really sure about it.
No, absolutely. Big IP concerns, right? What goes into the data, both consumer data, but also are you feeding in stuff that's protected by copyright or IP infringement? There are lots of lawsuits right now brought by the New York Times which said, AI companies have taken our newspaper contents and put it into their systems, and is that a copyright violation? So the integrity of the data, including respecting consumer privacy rights, respecting existing IP laws. Any other AI concerns from a human rights perspective? I'm sort of trying to figure out this field, and I come to you. Be careful.
Thank you. My question is, in an AI situation or in a situation that has been a violation caused by an AI or a technology, for example, when you talk of like law of armed conflict, for example, if Microsoft develops a software or a robot that is then procured by country X, and that robot or that software is used to violate human rights. The liability, who is legally liable? Is it the developer or the consumer? And in the instance of consumers, for example, in the law of armed conflict, for example, if there is an intervention, and in instances of someone has surrendered, how they are supposed to be treated. Soldiers have surrendered. Now, in this case, we have robots. If maybe a robot is not able to identify that these soldiers, they have been in a conflict, but they have surrendered and they go on to shoot and kill. Because they are robots, they cannot detect that. Who is liable? Is it the software developer or the country that deployed the robots?
Sure. Well, this is something that I think you're going to get in the next panel on this specific issue, but I'm going to turn it back to you. You identified the problem very clearly, right? What would you say is the solution, right? In this situation, I'm the new director of this company, and I've come to you to say exactly that issue, that we are developing technology whereby autonomous entities are going into the battlefield and making certain decision-making based on the data and information available to them. And I'm concerned because it's being deployed by the purchaser of these entities that I'm putting out into the world. Who is responsible? Will it be the purchaser? Will it be me? How would you tell me to think through that issue? I know it's unfair. You asked me the question, I'm lecturing, but this is the point of discussing how to identify these issues.
If they came to me for legal advice, as a company, I would advise them maybe to issue disclaimer to the consumers that if you use our product in such a way, we are not liable. But I don't know in practice whether it's what is being done.
Sure. All right. We have one solution, disclaimers. Any other? Yes?
I think what my colleague is trying to speak about is the copyrights and the data labeling, if I'm not mistaken. But to that, I can add as well the right to due process and digital legal security. I would also mention the right to remedy and the right to information.
So just expand on that. Tell me what that means.
Because these are all human rights concerns when it comes to AI. Because me, as a user, for example, of AI, I would like to have my data. I think the latest AI I saw a week ago, the latest update, it was saying, for example, correct me if I'm wrong, in the USA, like the AI now, it's from now on, it's going to store all the questions and the interaction with the human being on the gadgets and devices. So in future, if needed for legal reasons, the companies who hold those data can share them with the concerned authorities for trial and so on. So to what extent this information can be shared, me as a user, for example? There are some things that are meant to be kept private. I don't want them to go public. And there are those that can be shared without any issue. This is what I mean with the right to digital information security.
Okay.
So and the right to due process, it's if there is, for example, I'm working in AI and I have a different with another company or with an individual, to what extent I'm legally protected and I will have a fair judgment and I will have access to fair administrative procedures.
Sure.
To go on. Same goes to right to remedy.
So let's break those two issues down. On the first one, you've identified the issue. Actually, I'm going to stay with you, so maybe you keep the microphone, if that's okay. Yes. So on your first issue, you are a user, and you're logging into this AI tool, and you're asking this AI tool questions. What expectation of privacy do you have? You've identified, you said some of it should be private, but then you've also said maybe they'll share it with law enforcement officers. When you're going on to www.aihelpme.com and you're asking these questions of the tool, what expectation of privacy do you have? Because I'm asking you this question as now the company, right? I'm saying to you, well, what do I do then? Because I want people to use it. What are they expecting of me in terms of their human rights guarantees under human rights law? What would you tell me?
I would ask you the same question saying when you use the iCloud, to what extent you expect Apple to protect your data information? It's like they're selling you a product and you are giving them trust. This is how they gain the notoriety. For example, to be able to be a trustworthy product, you provide me a service and that service goes with protection.
Are they just, are you just giving them
I see it
trust?
the same level as, for example, going to a doctor, and having some medical issues. I have no problem with sharing them, but I have a problem with them going public without my consent.
Okay, but in that instance of the doctor, there's a privilege, right? There is a patient privilege. You have an expectation that's grounded in law that that information will be kept confidential. And so if the doctor is to share it in a way that's not authorized, there is accountability. With Apple in this instance in the cloud, do you just trust Apple? Or do you click on something that says, Apple, you can do, if I use your product, you can do certain things that are enshrined in the user agreement that nobody reads?
Either from personal or professional point of view, in every deal we do, there is some clause of confidentiality. Either when you sign a contract, when you buy a product, technically you sign a contract with the company. When you deal between two companies, you sign an agreement, there is a disclosure clause that protects the confidentiality of the information. So this goes without saying that any party should disclose to a third party the content of that product without the written consentment of the concerned party. I don't know to what extent I'm explaining myself.
No, you are explaining yourself, but what I suspect, and I have not looked at the Apple user agreement very recently, I suspect it says you have an expectation of confidentiality subject to certain exceptions. For example, if law enforcement authorities have a reasonable basis or a judicial subpoena or warrant to get this information, then we will turn it over to them. And your consent is expressed in you agreeing to this exception in the user agreement. And so they may not come back to you on the individual instance, but by and large, they have set out that legal framework. Now, there is a question of unconscionability and what can you reasonably be expected to agree to, and that's all contract law stuff. And that's what's interesting, right? Because we're looking at contract law issues here that may raise human rights concerns of like the right to privacy, for example. But oftentimes this is addressed in these kinds of things. The terms of agreement with whoever's using your drones in warfare, in terms of you using and the AI tool to chat with, and what expectation of privacy you have grounded in a contractual relationship with that entity. Let's go to the Microsoft example because it addresses exactly these issues, right? So there were concerns raised that the amount of activity for certain Microsoft services increased with the Israeli military department, within a certain period of time that were connected, according to the complainant, to certain activities that were taking place in Gaza. And so questions were raised as to whether Microsoft's products, the cloud, the Azure cloud, as well as other AI tools, were facilitating what was taking place by the Israeli operations in Gaza. And a shareholder filed a lawsuit, or didn't file a lawsuit, excuse me, at one of the shareholder meetings. It said, we have major concerns that your tools are being misused, in this instance by the Israeli military department. Here's what Microsoft responded, and it's a multi-paragraph response, and you only have one. One it did was, it said, we respect business and human rights, we have a human rights due diligence policy, we take all of these concerns very seriously, right? But then it had this paragraph, which is what actually created a lot of problems for certain members of the international community. It is important to acknowledge that Microsoft does not have visibility into how customers use our software on their servers or other devices. This is typically the case for on-premise software. Nor do we have visibility to the Israeli government's cloud operations, which are supported through contracts with cloud providers other than Microsoft. By definition, our reviews do not cover these situations. Right? So there's lots of stuff that's happening here. One is, where is the stuff taking place? Is it using our product on whose servers? Is it Israeli servers? Is it third-party servers? Because we know that this department is contracting with multiple service providers. So whatever activity that you're complaining of may not be, strictly speaking, our product, our problem. Right? That's one aspect. In other paragraphs, they say, we require users, purchasers of our services, to agree to and comply with Microsoft's human rights policies. But in another part of their statement, they also say, occasionally, we allow more advanced or different services for law enforcement officers, for cybersecurity, governmental experts. There are limited constraints in which they can use these services, but we want you to know this stuff is not available to everyone, to the ordinary user. There's different classification and categorization of who can do what with our products, right? So it was trying to parse out all of this stuff, and then it had reference to commitment to human rights, and that's about a page-long or two-page-long statement, and it says, we make it clear to our customers that we expect them to respect applicable laws in the use of our products and services. For our public sector customers, this may include international human rights law and international humanitarian law, the law of armed conflict. So it's also saying that, to the point of the contracting, disclaiming of liability, to the point of down-the-line users, these terms are being put in which there's a reference, probably, in these contractual agreements with purchasers of services that limits, that sets forth that, we expect you to comply with these things. The question now, is that good enough, right? Is that, maybe strictly speaking, is that good enough under applicable law? There's a reputational issue. This is where, Microsoft shareholder has said, we don't want you to continue to provide the service anymore to this particular user because, and you yourself are saying you don't know the limits of how this is being used. Some of this is for very strict reasons. Someone else's server, a third-party server, the Israeli government server. But some of this is your own admission that you will not be able to know how this is used. And that is the human rights concern, right? That is the impact, not just within the business, but it is in the entire value chain, that the product that you're putting out into the world, how can it be maybe misused? And are you accountable then under human rights law for, in some ways, whatever that legal standard is, and that's what we're trying to flesh out, being accountable for that product existing in the world, that may be violating the human rights of affected civilians. So this is a major issue that's going on right now, but it applies, this is a stark example because it's in the context perhaps of, we're talking about armed conflict and international humanitarian law, but it goes towards other more basic things that happen in society. I just wanted to ask, any other human rights risks that we can identify? Yes.
Professor, mine is still on the data privacy. Isn't there a way that they can add or rather my proposed solution would be, especially with regards to the spywares, if it can be added to the functionality of these apps so that if someone is spying on me, I get a notification that I should be aware that I am being spied on. If someone has access to my camera, could I get a notification that someone is viewing me? So then I can decide whether I want to be viewed or whether I want to put my gadget away, you know. And then in terms of uploading documents, say when you're using AI to analyze data and when you're asking AI certain pertinent questions, I think there should be a prompt that when you're if you upload this document, then this document is going to be stored and can be used in such and such a manner at the time you are uploading the document so that you can weigh on whether or not to upload that document. Because if you upload a document, say, touching on sensitive or vulnerable people or protect witnesses, maybe a witness under protection, you can subject them to some form of danger or something like that. So maybe those prompts, in my opinion, would solve a lot of the problems that we have with AI.
Sure. So that is actually, in a way you framed it as the right to privacy or privacy legislation. We could ground it in the human right to privacy and expectations of that, and then say that an investigation run by this very capable delegate has looked into ways in which we can mitigate or prevent, minimize the risk of this human rights abuse occurring, the unwanted viewing, for example. And these are steps in which we can remediate or prevent that from happening. And if there's an instance in which, notwithstanding these prompts have taken place, then have we done enough to notify the user of this potential risk such that we no longer have liability? So that is part of a human rights due diligence. You are identifying a risk that could happen. You are then proposing steps that can be used to mitigate or prevent that risk from materializing. You will track the effectiveness of it. Maybe it's the case that that prompt happens 100 times, and 100 times out of that, people just click ignore. Is it an effective prompt then, right? Because then it's not actually doing its job. So you'd have to track the effectiveness. If it is effective, then are we okay with it? If it's not effective, do we have another solution? If we don't have another solution, do we have to stop providing that service because of that risk? And is that, then we have to go into how serious is the harm and so forth. It may be the case that for children, for example, or vulnerable users, we have to have heightened protections, right? And therefore we have to impose an age limit. And maybe we say that users between 13 and 18 can access our app or our services, but they can have only limited things they can do. For example, perhaps this category, do not have the right to upload things because we don't want them to be putting stuff out into the world. And so you have to tier it then based on vulnerable populations. So these are the ways in which you've got to be thinking through responsible business conduct, but also then, which is now grounded in sort of this idea of respecting human rights and the human rights due diligence that we were talking about. So that was a great explanation of a way in which this can be achieved. Any other human rights concerns in the AI sector?
I was thinking about the effect, the strain it puts on resources, because when we think about it, AI technology uses a lot of energy, and also at the end of the day, it has to cool down, so it uses a lot of water as well. At the moment, companies are moving their servers to places where the resources, like in terms of water, are being the communities are being affected because the water that they have is being used for the servers rather than being supplied to the communities. So basically, if you think about it internationally, it's like people from all over the world using one service, but it affects the resources of one specific community in wherever the company decides to base its servers.
I'm so glad you went there because, this is something that seems a little bit removed, right? We're used to thinking about data, the data that's in the database, then the application of that data, the concerns about misuse. But this aspect of these massive data centers, right? All this stuff that's being gathered and stored and is humming away, where are these data centers being built? And how much energy do they consume? And they consume enormous amounts of energy, right? And this raises questions of where do we store them? Who own that land? Where is power being diverted to drive those servers? And things like water, where is it being diverted away from? I know that we're coming to time, if we had longer, for example, there's a study I wanted to go through on renewable energy, right? This is the panacea for our sort of like, we're moving into renewable energy to get away from the climate change issues of the extractives industry and fossil fuel. But are there similar concerns of where do we house the wind farms or the solar farms, and whose land, and with what local communities that are being impacted in terms of their livelihood, and with what resources that are going to fuel or power these new sources of energy or data centers that are housing all the data for this AI, and with what concerns. One of the biggest issues that we put forward in the submission to the Inter-American Court of Human Rights when I was working with those special human rights rapporteurs were these questions. That we think about carbon capture, right, new technology. We think about carbon storage, suck it out with a vacuum cleaner, put it under the ground. All of these solutions that are meant to adapt to and mitigate the climate change GHG emission content scope, they also have related problems of the right to land, the right to water, the rights of indigenous peoples and local communities, the rights even of, are these companies, AI companies, hiring without discrimination, or are they choosing subsets of population? Are they providing access to these companies to all users, or is it a select category of users? One of the big issues with underlying data sets is this a representative sample of data, or are we feeding into the data certain things such that the outputs that are coming will perpetuate issues of bias, of discrimination, right? So not just the consent to the data being used, but the integrity of that data set, and is it representative? There was a question that I think you raised about the person to your left raised about due process, right? Adjudicators who in small instances of like disputes under $1,000, your cell phone bill, do you need to go ahead and set that up for a judge to make that determination, an administrative judge? Or can you have, you file your complaint, the telephone company puts in their response, and because it's low stakes, quote unquote, monetary damages is low, we allow a decision maker who's an artificial intelligence decision maker to rely on the history of decisions that have come out and make its independent decision. Is that good enough for due process? Where do we draw those lines? These are a lot of the tough issues that I think the next panel will cover. I think we are almost at time, so let me just take a step back and ask, are there any more questions? I've really enjoyed all our interactions. There are a couple, so maybe start there and then go down the line.
I think my question is more fundamental. Since the discussions now are evolving in terms of the new transitional phase marked by the concept of digital sovereignty, do you think that we can speak just yet of a draft convention within the frame of multilateralism and global governance, or it's too early?
Okay. I'm going to take a series of questions so that we get them out and we can answer. So maybe pass the mic down to the next, I think it was 3 or 4 individuals down.
Thank you very much. I see AI very much linked to IT also. We are already suffering some of the consequences of the great development of IT. The right to privacy has been mentioned. I think the right to work has also been mentioned. Obviously, AI will replace millions of work, maybe in the near future. Work, I say, workers. Freedom of conscience, because the media influences the way of thinking of people, and at one point in time, the person thinks that the thoughts that he or she is having are their own thoughts, but it's not really, it's the media that has reached, and voila, the freedom of conscience of that person has been affected. Information, the right to information, in the sense that with the development of AI and the IT nowadays, there is a lot of misinformation. So the right of the persons to reach or have access to the truth and the right information is being affected. And in the case of misuses, in the case of misuse, there can be many violations of human rights, and as you mentioned, we don't know what will happen in the future. For example, right to freedom, AI may be used to control movement, freedom of movement, and other kinds of rights of freedom. And taking part in the government, we had a presentation here about how cyberspace can infiltrate or have influence in the elections of the various countries. So the right to vote of a person has been affected if in cases that that kind of technology is used. Thank you.
Thank you, and to your right, I guess.
Good morning. I was just concerned about the freedom of industry. A lot of countries have freedom of industry as a constitutional and fundamental right, and I was wondering about if there were instances where freedom of industry took over business and human rights, especially in regions like the EU, where it was expected from countries to implement certain rules to protect the environment, for example. But, for example, France has more strict regulations on fossils, for example, but Spain doesn't. And how does that, has there been any businesses that took that to a higher court and said that there is, for example, a violation of freedom of industry and how it is going to result in equality inside the region? I was just concerned on that point of view.
Thank you. I know that we are 5 minutes past time. I know we have a tough schedule, so I'll have a short answer. I'm sorry, you can come speak to me during the break. I guess I will say a couple of things. The first is, it's great that some of these questions and comments are going towards identifying the problem, right? And you're identifying the problem from a human rights lens. You're identifying certain human rights that are enshrined in different sources of law. You're referencing things like the right to privacy, the right to work, and so forth. And then the question becomes, do we draft legislation in different countries to address these problems? And that's sort of being done at local levels and national levels in things like privacy legislation or consumer rights legislation. So that's one question. Then the part that happens is, under international law, what do we do? And there was the first comment, right, on this sort of, a multilateral convention to address these problems. I'm not going to go into these slides, but there is, within the European Union, the Artificial Intelligence Act, and there is in the last bullet point you see, or the last category, the Framework Convention on Artificial Intelligence, which has been open for vote, and some, countries have signed up to already, that deal with fundamental principles and then remedies procedural rights and safeguards that are being put in. So there are attempts at a general level to have multilateral, multinational solutions, but the reality is that much of this work is being done at the domestic and national levels. And I guess my final comment to you would be, though, in some ways this is a very young field, right? We're talking about a field of business and human rights under international law that's of this century, and we're seeing efforts to then address it at a national level. We're seeing efforts at an international level in the form of soft instruments, but also now on certain categories of things like climate change. We have agreements that have human rights implications, like this AI convention that recognizes human rights implications. And that's actually what makes it also a pretty exciting field in which there'll be a lot of responsibility and roles for all of you here in your home jurisdictions. And that's it. All right. Thank you very much.
Thank you very much.